Greetings to one and all. You're listening to MMJC podcast. With the beginning of new financial year, we are here with a new initiative. We will be now onwards giving to you the important regulatory and industry updates which may prove essential or useful to our listeners. So to begin with, the first update relates to a SEBI circular and an informal guidance given by SEBI to DCB Bank and Pakka Limited with respect to compliance officer occupying the position one level below the board. So to guide us about this circular, we have with us CS Mr. Vallabh Joshi, Senior Manager from R&D team of MMJC.
Thank you, Rutuja. Beginning with the first update, one level below the board clarification. So SEBI had floated a consultation paper in last year, June, and where they had proposed this amendment of having compliance officer position one level below the board of directors of the company. So this amendment was approved by SEBI board meeting dated 30th September 2024. And finally, on 12th of December 2024, this amendment got notified. Post notification of this amendment, there was a lot of discussion around what does it mean by the word one level below the board. So does one level below the board would mean actually one level below the board, or it would only mean that the compliance officer shall report to the board? He may not be one level below the board in the hierarchy of the manager. So after this lot of discussions and questions which were posed to SEBI and other regulators, SEBI has now clarified by way of clarification dated April 1, 2025, that one level below the board means one level below the managing director or whole-time directors of the company, or in their absence, below the CEO or the manager of the company, ensuring that alignment with the KMP requirements under LODR and company plan. So the purpose of having compliance officer one level below the board, as stated by SEBI in the consultation paper, was that key compliance officer has a duty to advise on board on various matters. He is also required to give guidance to board on various matters under Companies Act and LODR and PIT. So in order to help him comply or help him fulfill his duty properly, it is necessary that he shall be one level below the board. Also, company secretary, compliance officer is a senior management personnel as per LODR. Hence, he should always be one level below the board. The amendment got approved, also got notified, and now after a lot of discussion around that, SEBI has clarified it by way of its circular dated April 1 that one level below, by the term one level below, SEBI actually meant that he shall be one level below the managing director WTD in the company's hierarchy. And it is not just about reporting, but about hierarchy also. So now with this, compliance officer shall be one level below the board so that he is able to report to the board of directors and advise the board of directors wherever necessary. This was also reiterated by SEBI in the informal guidance given to DCB Bank and Pakka Limited. We have covered here only for DCB Bank. Pakka Limited is also on similar lines. Here, SEBI has again reiterated that one level below the board would mean that he is one level below the managing director or full-time director of the company. DCB Bank had posed a question specific giving the hierarchy of the company, but SEBI, while replying to the question and giving guidance, has given an interpretation of Regulation 6, where this word one level below has been used. SEBI has also given an interpretation centric answer where they have mentioned that the word level and reporting are used differently in LODR in different regulations. And where word level has been mentioned, it means in the hierarchy, the next level. And reporting wherever has been used has a specific meaning assigned to it under that specific regulation. So they have to be read individually wherever they have been placed. And accordingly, SEBI has reiterated that one level below would mean exactly one level below the managing director or WTD.
Okay. So that means now compliance officer will be one level below in the managing director in the hierarchy of the company, and reporting will by default follow.
Correct.
Okay. So, sir, are there any more regulatory updates from the side of SEBI?
Not exactly from the side of SEBI, but there are regulatory updates from stock exchanges. So Bombay Stock Exchange has issued circulars dated April 1 and April 2nd, 2025. They are regarding integrated filing which have started for 31st March quarter ended and year ended 31st March 2025. So now BSE has, by its April 1, 2025 circular stated that integrated filing governance for quarter ended and year ended, as the case may be, 31st March 2025 will have to be filed in XBRL format. Last quarter only integrated filing started, December 31st, but last quarter till some time, some period of time, it was in PDF form, and now it will be purely in XBRL form, is what BSE has stated. Second circular of April dated, said BSE has stated that integrated filing financials will also be in XBRL utility. So integrated filing financials for 31st December was in PDF form because the XBRL utility might not be ready at that point in time, but it is now ready and it will have to be done in XBRL form is what BSE has specified. Integrated filing governance and integrated filing financials are notified by the same amendment, which notified the one level below board provisions under Regulation 6. Integrated filing governance and integrated filing financials are a cumulative set of reports which have to be filed in one go on a one day, that is within 30th day, and for financials as the timeline was specified earlier. So this is an ease of doing business which was brought by SEBI. And now, exactly on 30th day, that is within 30 days, I have to file my integrated filing governance, which will comprise of my CGR, that is corporate governance report, investor grievance report, and disclosures regarding acquisitions, uh, then penalties and tax litigation updates. And integrated filing financials will comprise of financials, RPTs, deviations in utilization of funds. So this will definitely bring ease. It has already brought in ease, but with XBRL, it will make it further simple for companies to file.
Okay. So the next update is has originated from the Union Budget 2025. In the budget, the Honorable Finance Minister had talked about giving additional benefits to MSMEs, that is micro, small, and medium enterprises. So, in this connection, the Ministry of Micro, Small, and Medium Enterprises has revised the limits of investment and turnover, which are used for classification of enterprises into medium, small, and micro enterprise. So, due to this change, more number of enterprises will be covered in these categories, and they will be able to take advantage of the government schemes. These new limits, uh, as visible on the slide, will be effective from 1st April 2025. So all the MSMEs which were existing as at 31st March will have to do their compliances for the financial year 24-25 as per as at the limits as available on 31st March, that is old limits. But whichever MSMEs will be formed after 1st April, they will be applicable new limits.
Okay, Rudra. So, is there any other update?
Yes, sir. There is one more update. In September 2024, an amendment was done in the companies merger rules, that is, companies which provide for merger of companies. So, fast track reverse merger of holding companies outside India with the subsidiaries in India was allowed. So, first case of this kind, where the first merger of this kind is done by Dream 11 company, that is Spota Technologies, is the Indian subsidiary in which the foreign holding company has merged. In this case, the approval of NCLT is not required. The approval of RD is sufficient for this fast track merger. In addition to this, what MCA in its report, which was released in 2022, the company law committee report, had given some recommendations about fast track mergers. So, according to that report, MCA has released a draft notification with respect to fast track merger, wherein it is proposing to include various classes of companies who will be allowed to do fast track mergers, and public comments have been sought on this draft notification. So, public can give their comments. Stakeholders can give their comments up to 5 May 2025 on this draft notification. Sir, would you like to add anything?
Yeah, there is one more part of due dates which are falling in the month of April. So these are due dates from the Companies Act side, that is Companies Act compliances. So the due dates falling in the month of April, the first due date is filing of Form MSME 1, and the due date of this form has to be filed by 30th April. The second due date is transfer of unspent CSR amount relating to ongoing project needs to be transferred to a separate bank account. And again, the due date for this is it has to be done within a period of by 30th April, not within a period, by 30th April it has to be done. So these are the two due dates in the month of April which stakeholders needs to take care of.
Thank you, sir. Thank you to our listeners for listening to us. Please feel free to write to us about your feedbacks and do let us know how do you like this new initiative of ours. Thank you.
Thank you, Rutuja.